Today we switch gears and move away from political speech, as in Citizens United, where anybody who believes in free speech believes that political speech ought to be free. You might quarrel with the idea that corporations get to engage in the political marketplace of ideas, but there isn't really any dispute that in a democracy you need free political speech. But today we move to a different kind of speech that may or may not be political, subversive, or protest speech, including symbolic speech, speech without words. And this is one of my categories of speech. You won't find this officially anywhere else. This group of cases, this category of subversive and protest speech, involves speech that most people don't want to hear, that do not. This is speech that does not command a majority support, and the government, responsive to majority will, would just as soon suppress this kind of speech. So let's go back to the beginning and the Sedition Act of 1798. I'm going to go through the materials today and Thursday, more or less historically. And here's a law passed by the Congress 7 years after the adoption of the First Amendment, voted for by many of the founding generation who had written the Constitution. And they enact this law that makes it a federal crime to publish any false, scandalous, and malicious writing against the government of the United States, or either House of Congress of the United States, or the President of the United States, with intent to defame them, bring them into contempt or disrepute, excite the hatred of the good people of the United States against them, or stir up sedition. How do you think the Supreme Court ruled on that law? Nick? What case? Schenck? They upheld it in the Schenck case? When was the Schenck case? Yeah, when was the Schenck case decided? 1919, right? The Sedition Act of 1798 expired by its own terms in 1801, the day before President Thomas Jefferson took office. And while several editors of newspapers were convicted under the Sedition Act and imprisoned, none of their cases ever reached the Supreme Court before the law expired in 1801. So the Sedition Act of 1798 was never ruled on by the Supreme Court. It was certainly considered, and the court essentially condemned it in the court of history in New York Times versus Sullivan in 1964, which we'll look at in great detail in a couple of weeks. But it's somewhat surprising that the Sedition Act itself was never adjudicated, was never the subject of a ruling by the United States Supreme Court. Notice something about the law. It makes it a crime to say false, scandalous, and malicious things about the Congress, various officials, and the President. Notice that who's missing here is the Vice President. Perfectly fine to say false, scandalous, and malicious things about the Vice President. How did that happen? Well, the Sedition Act was an effort by the Federalists. The parties then were the Federalists and the Republicans. And the Federalists, who had promoted the Constitution, were in office. President John Adams was in charge. But in those days, you could have a Vice President of a different party from the President. And the Vice President, at the time the Sedition Act was written, was none other than Thomas Jefferson, a Republican. And the Federalists, in enacting the Sedition Act, were attempting to save our fragile new democracy from being drawn into the European conflicts. And the Federalists were terribly afraid that the Republicans were going to get in bed with the French and we'd have another war on our hands. And the Republican newspapers at the time were intensely partisan, about as much as cable television is today. Predictably, they would support one party or another. And the Federalists were terribly concerned that the Republican newspapers were subverting this new democracy by being critical, sometimes truthfully, sometimes not, of what the Federalist administration was doing. And so they enacted the Sedition Act and enforced it by criminal prosecutions, leading to the conviction and imprisonment of, I forget the number, 15, 16 editors of newspapers. But their cases didn't reach the Supreme Court. The Sedition Act itself stands as a historic landmark, and a very puzzling landmark it is, given that, wouldn't you think that the same people who wrote the First Amendment would have realized that the Sedition Act is baldly unconstitutional, completely inconsistent with what the Supreme Court would later call the central meaning of the First Amendment, which is the right that we all have to criticize government. Here's a law that makes it a crime to criticize government. Well, not much happened in the way of congressional or Supreme Court activity with regard to subversive speech for well over a century after the Sedition Act. And the first case that the Supreme Court ever gave full consideration to a First Amendment claim in was the Schenck case in 1919, in the aftermath of World War I. And Charles Schenck was a left-winger, socialist, who distributed leaflets opposing the draft during World War I. They had a military draft, and his pamphlets said that conscription, the draft, was basically slavery. It was prohibited by the 13th Amendment to the Constitution, and young men eligible for the draft ought to stand up for their constitutional rights and resist the draft. And Schenck was prosecuted by the federal government for violating the Espionage Act of 1917, which, among other things, prohibited encouraging disloyalty in the military. The Espionage Act of 1917 was basically the first law since the Sedition Act in which Congress attempted to restrict speech. And the opinion in the Schenck case was written by Justice Oliver Wendell Holmes, and aside from the fact that it's the first time that the court ever grappled with the extent to which the First Amendment protects speech, the opinion is famous for two features. One is yelling fire in a crowded theater, that metaphor, and the other is the clear and present danger test. Both of these probably sound somewhat familiar to you. On the merits of the decision, Schenck, it was a terrible decision. I mean, here is somebody distributing leaflets on paper, arguing about the Constitution and the war, and opposing the war, commenting on government policy, critical of Wall Street, foreshadowing the Occupy movement. And it's unthinkable that anybody could be prosecuted today for what Schenck did. But the opinion by Justice Holmes prefaces the ruling by saying that free speech is not an absolute, but saying that it would not protect a man in falsely shouting fire in a theater and causing panic. No notion, in his view, of free speech would protect someone in falsely shouting fire in a theater and causing panic. That's a memorable image. It has stuck with us through the decades since 1919. Often people's first reaction, for example, last fall, right around 9/11, the anniversary of 9/11, when a video was produced called Innocence of Muslims and was put up on YouTube and caused the death of 49 people around the world in various demonstrations against the video, a lot of people said, geez, well, you can't produce a video like that and put it out there. That's like yelling fire in a crowded theater and should be suppressed. So that image about yelling fire in a theater has stuck with us. By the way, the popular version of that slogan usually omits the word falsely. What Holmes said was falsely yelling fire. And the popular version usually omits causing a panic. Those two omissions make the slogan much more speech restrictive than it actually is. And Holmes's version may be justifiable, I suppose is justifiable, because shouting fire in a theater would have an immediate effect on the people who hear the speech, who are right there, and who then panic, causing harm. And, according to Holmes, the speech is both false and unrelated to any public issue at all. I would say that shouting fire in a theater is garden variety disturbing the peace. Sure, it can be prosecuted as a misdemeanor. But that metaphor has no place in a case that is dealing with criticism of government policy, as Schenck was. So having established by this metaphor that free speech is not an absolute, Holmes, who wrote very brief, pithy opinions, wrote them standing up. He wrote at a stand-up desk, wrote them out in hand. He was on the Supreme Court forever. He then undertook to establish a test for deciding when speech can be suppressed by government, subversive speech of the kind that Schenck had engaged in. And the test is whether the words create a clear and present danger that they, the words, will bring about the substantive evils that Congress has a right to prevent. And, for example, everybody would agree that Congress has the right to prevent grave, immediate, irreparable threats to the national security and other things. And in this case, Congress had a right to prevent disloyalty, people going around stirring up disloyalty in the military. And therefore, the interest that Congress was advocating was served by this law, the Espionage Act of 1917, was an important interest, and it's one that Congress had a right to address. And then the court determined that Schenck's activities met the clear and present danger test, that his distribution of these leaflets created a clear and present danger of disloyalty in the military. The test, clear and present danger, sounds like it has some teeth. Sounds like it may be a real restriction on government's power to suppress speech that it doesn't like and would like to suppress. But in fact, and in practice, the clear and present danger test turned out to be toothless. It was in that same year of 1919, in that same term of the Supreme Court that Schenck was decided. Schenck was decided in the late spring, early summer. The court decided two other cases, one of which involved the conviction of Eugene Debs, a several-time candidate for president of the United States, a socialist, an anti-war activist who had made a speech somewhere in Ohio in which he talked about socialist goals and so on, but also praised three young men for their resistance to the draft. And Debs, the presidential candidate, was convicted and sentenced to prison. The court upheld that. And then following 1919, sometime in the fall of that very same year, 1919, Holmes changed his mind. Not about the test. He continued to believe that the proper test would be the clear and present danger test, but he would apply it very differently. And that same fall, he wrote a wonderful opinion in United States versus Abrams, which was a dissent from another conviction in the aftermath of World War I of a dissenter for opposing government policy. That was the Abrams case. And Holmes continued to dissent through the 20s in all of these subversive speech cases. And unfortunately, the court continued to apply the clear and present danger test, the majority of the court did, and upheld the convictions of these various dissidents, Schenck, Debs. Then there was Gitlow, Benjamin Gitlow, whom I mentioned before, was another socialist. His case came up out of New York. His conviction was upheld under the clear and present danger case. The Whitney case in California, another subversive, goes to prison. And the court continued to uphold convictions of subversive speakers right up through the McCarthy era in the early 50s, where the communists were convicted and sentenced to prison for conspiring to overthrow the government of the United States through speech. So the clear and present danger case was not much of a barrier to government suppression of speech that it considered having a dangerous tendency to subvert government goals. But then things started to brighten with Yetta Stromberg's case, decided in 1931. Yetta was 19 years old, a UCLA student in 1929, when she worked as a counselor in a camp in the San Bernardino Mountains, a camp for the children of communist families in the Los Angeles area. And the kids went to some camps, kids from 6 to 16, and Yetta was one of the counselors, and she would get them up in her group every morning, get them off the cots. They stand next to their cot. One of the kids would raise a little triangular hammer and sickle red flag up the flagpole, and the students would stand and give a charming pledge of allegiance to the communist flag, the pledge that I put in the chapter on Yetta in the Figures of Speech book. And at some point that summer, the camp was raided by a posse of American legionnaires led by the district attorney of San Bernardino County. And the posse arrested all of the adults at the camp cook and the counselors, and including the mom of one of the campers who happened to be visiting. They were all arrested, and they were charged with a felony under California law, a law passed in 1919, a law quite typical of the law of many states. Maybe 30 states passed similar laws at the conclusion of World War I after the Bolshevik Revolution in Russia, where the American establishment feared that Bolshevism would spread around the world, that our free enterprise system would be destroyed in a revolution here. And therefore they passed laws intended to contain the spread of communism. The law made it a crime, a felony, to display a red flag, just exactly what Yetta did, as a sign, symbol, or emblem of opposition to organized government. Yetta was convicted and sentenced to 1 to 10 years in prison for having violated this law. She appealed with the support of the American Civil Liberties Union. She was out on bail pending appeal, and she was a lifelong activist. She just died about 5 years ago. Was a teacher, but she was allowed bail pending appeal, and her case arrived in the Supreme Court in 1931, which decided in her favor, a 7-2 decision, an opinion written by Chief Justice Charles Evans Hughes, and the court held that the California law was invalid on its face. It violated the First Amendment. It infringed the right to oppose government and advocate change. And the takeaway from the Stromberg decision, is we do have the right, guaranteed by the First Amendment, to oppose our government. And the ability to advocate change is what makes us a free people. A couple of landmark type things about the Stromberg decision. This was the first time in American history, 1931, in which the Supreme Court decided that a law, either state or federal, was unconstitutional as a violation of the First Amendment. That's hard to believe. How could it take that long? Well, a couple of reasons occur to me. Remember that the First Amendment itself, by its terms, Congress shall make no law, still applies only to the federal government. And Congress had not enacted any speech-suppressing laws from the Sedition Act up until World War I. So there weren't laws passed by Congress that the court could have found unconstitutional for well over 100 years. And the states were free at least until 1868, the adoption of the 14th Amendment, to suppress speech and not violate the First Amendment, because the First Amendment did not apply to the states. And as I said a couple of weeks ago, not until 1925 did the Supreme Court decide that the word liberty in the Due Process Clause of the 14th Amendment incorporated the rules, the First Amendment rules, governing free speech and the press. That was the Gitlow case in 1925, which said that the provision of the 14th Amendment telling states they can't deprive a person of life, liberty, or property prohibits the states from denying people their First Amendment rights. There's our friend Gitlow. The other thing about Stromberg, which is